Last year, a man named Donald Sauve walked into a federal court, and he just handed the clerk this single handwritten piece of paper.
Right. Just a piece of
Yeah,
paper.
literally just a scrawl. And he was asking for $275,000. He claimed he'd been, unlawfully deprived of his home. And, well, as you might expect, when someone hands a federal judge a handwritten note, it was dismissed for lack of jurisdiction in, less than a month.
Which is pretty standard, yeah.
Exactly. But then, 3 months later, Sauve returned. And this time, he wasn't carrying a notebook. He was armed with ChatGPT and Claude.
Oh, wow.
Right. He submitted this neatly typed, perfectly formatted document accompanied by 50 additional filings and a complete case law synthesis, which, if you aren't familiar, is this highly complex document that weaves together historical court decisions to justify a legal argument. I mean, it's not something you just whip up on a Sunday afternoon.
No, definitely not. I mean, that jump from a handwritten plea to a 50-page synthesized legal strategy is completely unprecedented. We are watching individuals bypass years of specialized legal education with, a simple text prompt. It fundamentally rewrites how citizens interact with the American justice system.
And that transformation is the mission of our deep dive today. We're looking at this huge stack of sources, real-world federal court data, recent judicial rulings, and a brand new academic study from MIT.
Yeah, that MIT study is fascinating.
It really is, and all of it points to a massive structural shift. We're exploring how generative AI is supercharging what the courts call pro se litigation, cases where people represent themselves.
Yeah.
Because looking at Sauve's overnight transformation, it really feels like OpenAI and Anthropic have accidentally become the largest, most reckless pro bono law firms in the country.
Right.
And in doing so, they are triggering this massive AI governance crisis that threatens to actually literally break the courts.
Yeah, that phrasing of a reckless law firm hits right at the core of the issue. Because to understand why judges and state legislatures are currently in this governance panic, we first have to understand the sheer volume of data this new digital law firm is injecting into the system.
Right, the scale of it.
Exactly.
Yeah.
Let's look at the baseline load. Every single year, federal district courts handle roughly 300,000 new civil lawsuits, plus another 42,000 new cases in the courts of appeal.
That's already a lot.
It is. And even before AI entered the chat, a full third of that combined caseload came from pro se litigants.
Which makes sense, right? Because lawyers are incredibly expensive.
Yeah.
But traditionally, those self-represented plaintiffs faced an incredibly steep uphill battle, mainly because they just didn't know the procedural rules.
Right. But now, look at the data from the new MIT study led by Anand V. Shah. They found that the proportion of non-prisoner pro se cases jumped from 11% of all civil cases just 5 years ago to 16.8% in 2025.
Wait, almost 17%.
Yeah. But the metric causing absolute alarm bells in chambers across the country is the number of pro se complaints flagged as likely containing AI-generated text went from virtually zero in 2019 to over 18% in 2026.
Okay, let's unpack this. Because an 18% spike in a system already handling hundreds of thousands of cases is, well, it's a logistical nightmare.
It really is.
It's sort of like handing out megaphones to everyone in a crowded hospital emergency room. Suddenly, the courts can't hear the actual emergencies over the deafening, artificially amplified noise.
That's a great way to put it.
And the real crisis isn't just the noise, it's the triage. Suddenly, the intake nurses, or in this case, the court clerks, they can't separate the actual life-threatening emergencies from a stubbed toe because the AI makes the stubbed toe sound like a massive internal hemorrhage.
Right. Dresses it up in all this legal jargon.
Exactly. And every single generated page has to be read, captioned, and entered onto the public docket by a human being.
And that triage problem is exactly what the system is buckling under right now. Stephen Donahue, a staff attorney in Minnesota whose actual job is to review these pro se filings, he reported a 50% uptick in non-prisoner filings starting around March of 2025.
50%? That's wild.
It is. And it's entirely about how the technology functions. Generative AI is essentially the world's most advanced game of autocomplete.
Right.
It doesn't perform real legal reasoning. If a user feeds it a standard eviction notice and asks for defense, the AI just scans its training data for the most complex, successful-sounding legal defenses it has ever processed.
It doesn't actually understand the context.
Exactly. It doesn't know the user simply missed rent. It just knows that words like Fair Housing Act or constitutional due process often appear in successful housing lawsuits. So it just glues them together.
So it takes this mundane local landlord-tenant dispute and morphs it into a sweeping federal civil rights violation.
Yes.
Because the AI is designed to please the user. I mean, if you ask it to make a federal case out of your eviction, it doesn't advise you against it. It says, sure thing, here are 5 federal statutes we can string together to make you sound unstoppable.
And that autocomplete mechanism forces federal judges to spend hours, sometimes days, untangling this huge web of highly sophisticated-sounding legal jargon, only to realize at the very bottom of the pile that it's just a basic state-level disagreement over a security deposit.
Wow.
Yeah. As Anand Shah bluntly stated in the research, judges still only have 24 hours in a day. Something has to give at some point.
Well, we've established that the mechanism is drowning the clerks and judges, but to figure out how to govern this moving forward, we really have to look at the motivation.
Right. Why are people doing this?
Yeah, is it a malicious attack on the courts or an act of desperation? Because on one hand, there's a very real, very powerful democratization of justice happening here.
What's fascinating here is the historical context of that democratization. The American legal system has been profoundly shaped by unrepresented individuals. Look at Clarence Earl Gideon in 1963.
Oh, right, the Gideon case.
Yeah, he was a 52-year-old convict who wrote a handwritten petition to the Supreme Court that ultimately established the constitutional right to counsel for felony cases in state courts. One handwritten, legally flawed document shifted the entire landscape of American law.
And today, I mean, we still have a massive justice gap. We have a quote in our sources from Satish Nori, a legal aid lawyer in New York with 20 years of experience. He points out that despite a landmark 2017 law meant to guarantee free legal representation to low-income tenants facing eviction, city data shows that 50% of those tenants still face eviction without a lawyer.
Still 50%. That's staggering.
Half of them. And Donald Sauve himself told reporters that using AI is, quote, the only path forward for him, adding that knowledge is power.
Yeah, and Judge Michael Y. Scudder of the Seventh Circuit Court of Appeals actually echoed that sentiment recently. He acknowledged that AI presents great promise for enhancing access to justice for those without the resources to retain counsel. I mean, for someone facing the loss of their home, a generative AI chatbot isn't a shortcut, it's their only lifeline.
Here's where it gets really interesting, because I want to hold my ground on this point for a second.
Okay.
If you are that tenant facing eviction, and you have absolutely $0 to your name, your alternative is walking into a hostile courtroom entirely alone, which historically means an almost 100% chance of losing.
Yeah, the odds are terrible.
So mathematically speaking, isn't a 10% chance of success with a flawed, hallucinating AI lawyer still a vastly better bet for that individual?
Well, if the only two outcomes were winning or losing, that mathematical bet might make sense. But unsupervised AI introduces a third outcome: active, punitive harm to the user. A human lawyer's job isn't just to draft documents. It's to filter reality and protect the client from self-sabotage. A generative AI has this well-documented tendency to fabricate facts, what we call hallucinations.
Right, just makes things up.
Exactly. It turns out quasi-legal boilerplate that creates an illusion of legal merit. And when a desperate person submits those hallucinations to a federal judge, they aren't just losing their eviction case. They are committing perjury, waiving their rights to future appeals, or admitting to things that could invite severe financial sanctions.
Oh, wow. So they think they're filing a defense, but they're actually handing the judge a signed confession of frivolous litigation.
That is the real danger. Judge Joshua D. Wolson of the Eastern District of Pennsylvania warned about this at a recent judicial conference. The core function of a court is to separate truth from fiction.
Right.
When the technological cost of making fake things that look like truth drops to zero and the quality of those fakes goes up, it threatens the structural integrity of the entire judicial process.
Which brings us to the absolute core of our deep dive today: AI governance.
Yeah.
We have this undeniable clash between desperate citizens and an overwhelmed, rigid justice system. So how do we regulate a technology that is actively practicing law without a license? Who is actually liable when this completely falls apart?
That liability question is the defining legal battle of this decade.
Right.
Right now, we are watching a massive collision between corporate self-governance and actual state legislation.
Okay, let's look at how the AI companies govern themselves first.
Right. If you read the terms of service for Anthropic or OpenAI, and as a quick side note for you listening, the New York Times is currently suing OpenAI and Microsoft over copyright claims which they deny.
Right, important context.
But their terms of use are designed as a liability shield. They explicitly state that the user bears all responsibility for the output and that the tool should never be used as a substitute for professional advice.
So what does this all mean? It's like a pharmaceutical company setting up a booth on the street, handing out highly potent, unmarked pills, and putting a tiny disclaimer on the bottle that says, "You are the doctor now. Whatever happens to your body is entirely your fault."
That is exactly what it's like.
It's a high-stakes game of liability hot potato. The tech companies pass the liability to the user. The user, who usually doesn't know any better, swallows the pill, or in this case, passes the hallucinated laws to the judge. But according to our sources, state legislatures are looking at this and saying, no, if you manufacture the pill, you are liable for the side effects.
Exactly. States are actively exploring legislation to hold these AI companies directly liable if their chatbots dispense legal advice in place of licensed professionals. If we connect this to the bigger picture, the American justice system is suddenly becoming the front line for AI governance.
Because they can't afford to wait.
Right. We are shifting away from the era where tech companies could simply self-regulate with a checkbox on a website. Because the courts cannot wait for federal regulators to figure this out. They have to govern their own spaces right now just to keep the lights on.
Yeah. And the Administrative Office of the U.S. Courts is actively gathering information to formulate a response. But individual judges aren't waiting. They're already going on the offensive.
They are. They're issuing what are called standing orders.
Yeah.
Basically, a judge will post a local rule, like a massive warning sign on their specific docket, saying, if you use generative AI in this courtroom, you must disclose it, and if it's wrong, you will face serious penalties.
And we are already seeing those real consequences enforced. Like Judge Virginia Kendall, a federal judge in Illinois, she actually fined a pro se litigant $1,500.
Yeah, $1,500.
Because the litigant had twice submitted a fake case littered with hallucinated citations. Imagine the resources wasted there.
Oh.
Judge Kendall noted in her order how incredibly frustrating it is for her and her clerks to spend days attempting to locate non-existent cases.
Right, trying to unpack made-up factual assertions.
Only to realize they've been chasing synthetic ghosts. But, you know, the tragedy of that $1,500 fine is that it doesn't actually solve the governance problem.
No, not at all.
A person uses a free chatbot because they are broke. The chatbot confidently lies to them. The person submits it thinking they finally have a fighting chance, and the court slaps them with a fine they can't pay for violating a technical rule they didn't even understand.
Yeah.
You cannot find your way out of a systemic architectural issue. The user was actively misled by the design of the software.
Which is precisely why those state-level efforts to redefine this software as a regulated service are gaining so much traction. The argument is that providing a tool capable of generating bespoke legal strategy is not just providing a word processor, it's dispensing legal advice.
Wow.
And if you dispense legal advice, you are subject to the governance and disciplinary structures of the state bar. It forces actual courtroom enforcement rather than just corporate self-regulation.
But, you know, while the slow wheels of state legislation and corporate liability turn, the everyday people at the center of this aren't waiting around for permission. Let's return to Donald Sauve, the man we started with.
Oh, right.
He used ChatGPT to jump from a handwritten note to a massive 50-document filing.
And despite the polished formatting and all those sophisticated-sounding AI citations, the outcome was pretty inevitable.
Yeah, it was. 2 months after he filed his AI supercharged lawsuit, Judge Patrick J. Schiltz, the chief of Minnesota's federal district court, dismissed the suit again. But this time, it took the judge a 14-page opinion just to untangle the mess and explain that Sauve had failed to state a clear claim.
14 pages just to dismiss it.
Right. Judge Schiltz wrote that a litigant cannot just dump hundreds of pages of documents on a court and expect the court to sift through them to find facts. The system just isn't built to sustain that kind of burden.
And Judge Schiltz took a very drastic governance step to protect his own clerks. He entered a standing order stating that any further filings from Sauve would be, quote, shredded without any additional notice.
Wow. Literally shredded.
Yes. He later referred to this flood of AI-enabled pro se filings as an existential threat to the federal courts because the length and complexity of these synthetic filings are just compounding daily.
But the human reality here is that the threat of a paper shredder hasn't deterred Donald Sauve in the slightest. The sources paint a pretty stark picture of his life today. He is 69 years old.
Right.
He lost his home following a messy divorce that included a judge finding he abused his ex-wife and a child allegations that Sauve strongly denies, by the way. He believes the courts calling his filings frivolous is just a corrupt system protecting itself.
Yeah.
Today, he is living out of his car in Mora, Minnesota. And where is he spending his days? He is sitting at a table in a supermarket coffee shop, staring at his laptop, using AI to plan what he calls new SCOTUS-grade filings.
SCOTUS grade.
Yeah, he's preparing to blast the state Supreme Court, a federal appeals court, and a county court. When asked about his strategy, he literally said, "OpenAI told me this," and I think Claude will confirm it as well.
See, he fully believes the AI is validating his legal theories. It creates this huge echo chamber. The AI flatters the user feels legally empowered, and they just flood the zone with more documents.
And nothing stops them.
Exactly. If standing orders can't stop him, and fines won't deter someone who is already living in their car, how do the courts actually adapt?
That is the million-dollar question.
Well, the sources reveal a highly controversial strategy that's gaining traction behind closed doors. Fighting fire with fire.
Wait, really?
Yeah, some federal judges are actively discussing ways to use AI responsibly within their own chambers. The idea is to deploy internal language models to help judicial clerks read, summarize, and rapidly assess this massive influx of AI-generated public filings.
So we have an unrepresented citizen using an algorithm to write a 50-page lawsuit, and a federal clerk using a different algorithm to read and summarize that exact same lawsuit.
This raises an important question. If the volume of synthetic legal complaints becomes so vast that human judges and human clerks physically cannot read the daily docket, is AI-assisted judging the only satisfactory solution left to this existential threat?
Wow.
Are the courts being forced to adopt the very technology that is actively breaking them just to keep the lights on?
And that leaves you with something very heavy to mull over today on your own. We started by looking at a handwritten note from a desperate man. Even if it was legally flawed, it was a deeply human plea for help that a human judge actually read and evaluated. But if the future of our justice system involves desperate people using algorithms to mass-produce artificial lawsuits and overwhelmed courts relying on algorithms to triage and dismiss those exact lawsuits,
Yeah.
are we heading toward a reality where human empathy, human reasoning, and human judgment are entirely engineered out of the pursuit of justice?